there is a new lawsuit against Spotify taking or not paying royalties to our songwriters. $150 million in royalties are not going to be properly paid. Is it just me, or does Spotify seem more and more like a scam every day? You know, Mechanical Licensing Collective, they got Spotify on their toes. And we talk about Spotify because, look, as musicians, I am one. I've made music since I was basically 4. I learned classical music, and it's just something that I love. I'm so passionate about it. One of the frustrations can be sometimes about just the lack of meaningful revenue from streaming. And streaming is the way that most of us distribute our music and have it heard and have it consumed. And things have changed, right? The good old days of vinyl records, the good old days of CDs, and just getting physical sales and getting, I don't know, $15 for your new album versus essentially, putting it up for free. But there are streaming royalties. We covered that there is a new lawsuit against Spotify. And this is by the Mechanical Licensing Collective, which some of you, if you have not heard of this organization, please pay attention, because this is how you get some of your royalties. There are different organizations that pay you money, and we don't want you leaving money on the table. So it's important that we know the Mechanical Licensing Collective is one place you do want to register an account. Okay. So, basically the motion to dismiss filed by Spotify. So, Mechanical Licensing Collective comes on in and says, hey, we just got wind that you, Spotify, are basically taking or not paying royalties to our songwriters, to our publishers in the way that you are supposed to. So they filed a federal lawsuit, and they go, basically, we anticipate that just in the next year, it was something like $150 million in royalties are not going to be properly paid, because they're like, this is what Spotify did. Spotify purportedly bundled current subscriptions for Spotify users. And so you, the user, get to have access to the many, 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 many songs on the platform with your subscription. But they also added in 15 hours of audio book access. And, if you guys remember, we did a little bit of a deep dive into this, but there's the phono records for settlement of 2022. And pursuant to, this agreement, it basically says that if there's bundling, Spotify essentially would have the ability to change how much it pays out to songwriters. And so this is in the contract. So this is technically something that, Spotify would be able to do. So then what Mechanical Licensing Collective is doing, which it was put together as part of the Music Modernization Act of 2018. And, basically this organization is here to make sure that you guys get paid your mechanical royalties. And so when Spotify came in, they go, what we're doing is we're bundling. We're bundling this little audiobook thing into the access to the songs, and therefore it's going to dilute the royalty pool. All right, so Mechanical Licensing Collective is like, I don't think so. And we're going to look at the most recent filing. But just for context on it, that's where we landed. Spotify then filed a motion to dismiss, which basically is Spotify asking the court to just kick out the lawsuit altogether. This was filed in August. Spotify asked the court to dismiss the lawsuit brought by the Mechanical Licensing Collective over streaming services, reclassifying its premium subscriptions as bundles. So the conflict between the Mechanical Licensing Collective and Spotify began in March when Spotify reclassified its premium subscription tiers as bundles, as they now include 15 hours of audiobook access each month. What essentially was claimed in the complaint is that they're like, this isn't bundling. Bundling is okay pursuant to this contract that we all signed, but this isn't bundling because they go, no new service was added into this. And this is the distinction that the Mechanical Licensing Collective is trying to make. They're like, if you have 2 separate services and you put them together, therefore it's bundling. They go, that's not what Spotify did here. They go, there's an existing service, and now what they do is they add in 15 hours of audiobook listening. And so they go, we think that this is nonsense. And the ultimate result is that there's going to be a huge loss of revenues that are paid, right? So mechanical royalties that are paid to songwriters. The Mechanical Licensing Collective is a nonprofit organization designated by the U.S. Copyright Office to administer a blanket compulsory license and to ensure that music streaming services like Spotify pay the mechanical royalties they owe to songwriters and music publishers. And then, of course, the MLC filed a lawsuit against the streaming service in May, alleging that Spotify had underpaid royalties to songwriters and publishers as a result of this bundling move. And so they filed a very long 32-page complaint, which we went through in our prior video. And the Mechanical Licensing Collective argued it is originally brought, quote, one of the largest music streaming services in the United States has failed to comply with the Copyright Act and its implementing regulations. Basically, they go, complaint. In response, there's this motion to dismiss. And, Spotify is just like, we don't think that this has any teeth. Your Honor, you should just kick this out. I kind of just went through this. I have a couple of cases right now, and one of them that is in federal court, we had something similar. It's a motion to dismiss, but if someone has not answered, but it's called a motion for judgment on the pleadings if someone has answered. So we just kind of went through this whole thing. But let's see, what did the Mechanical Licensing Collective say in response? All right, so this is down on page 13. I won't bore you guys kind of going through the whole thing, but Mechanical Licensing Collective and their team, they open it by going, Spotify's motion pays mere lip service to the relevant legal standard, ignoring or disputing the well-pleaded facts in the complaint, improperly relying on purported facts from outside the complaint, and asking that the court disregard certain critical factual allegations. So, right out the gate, they're just like, they're not following protocol here. So, as a quick summary, what essentially Mechanical Licensing Collective comes back and argues is Mechanical Licensing Collective's allegations are true. And if the court is going to, approve a motion to dismiss, the court has to say there's something wrong with what was filed. Because here's the thing. In a motion to dismiss, it's a 12b6 motion. The court has to look at and see if there's something wrong with what was filed. So for example, if there's a lawsuit and there's a breach of contract claim, and in it they go, well, pursuant to the contract, we agreed jurisdiction was like in a different court. So for that reason alone, Your Honor, you gotta kick this out. Because there's a contract term that says you can't hear this case. And so if something like that is presented to the court might say, well, we don't have jurisdiction, so therefore we approve and grant dismissal. So the framework that this is typically looked at is taking everything that's put in the four corners of the complaint as true. Is it well pled? And could this, basically have some teeth to it? So that's the framework that the court has to look at. And so what the attorney did in this, response, the Mechanical Licensing Collective's position was just to say that, we pled everything we needed to plead and we're good to go on this, essentially. Music Attorney is your #1 legal resource for artists, producers, and record labels. Get contract templates, one-on-one legal advice, free masterclasses, and everything you need for your music business. Go to topmusicattorney.com. Is it just me or does Spotify seem more and more like a scam every day? I don't know. Look, if you guys are watching this later or during the live stream, drop a comment down below, because here's the thing. We talk a lot about the direct-to-fan model, and some people just don't even want to put their music on music platforms anymore for many reasons. A lot of you guys are having all kinds of trouble with these music platforms. You're having trouble with music distribution companies, and I understand that. And to the extent that you want to sell your music directly to your fans through your own website, right? By having your own PayPal, by doing your own merch and selling one-off products and all this good stuff. I think that is a route that a lot of people are missing out on in a way to really meaningfully build a fan base. So in any case, what we're going to see here is that now it's pending. All right. So, the last word on this is that MLC comes back. So #1, premium does not qualify as a bundle because it is not a combination of a music service and one or more other products or services, right? So we just talked about that. They go, this isn't a bundle. They're calling it a bundle. It really is not. The second part of their argument, they go, premium does not qualify as a bundle because the ability to listen to up to 15 hours of audiobook content is of no more than token value to premium subscribers. Come to think of it, I'm like, I listen to a lot more like podcasts and that kind of thing on Spotify, but even just my own consumption, I would say that I'm still not really consuming audiobooks, and I know that a lot more are available. So I'm curious with you guys, are you listening to audiobooks on Spotify? So, what they're claiming is they're like 15 hours of audiobook listening is no more than a token value. So it's really not of a separate, distinct value. That's what they're claiming. What do you think? All right, so those are the two big bases. And then they go on to say what Spotify tried to do was to present all these new facts that are not in the complaint. Because remember, we said that if you file a complaint and then someone responds and says, Your Honor, we want a motion to dismiss, the court has to look within the four corners of that complaint and just to be like, is it well pled so that everything taken is true, that these, that the mechanical licensing collective actually has legitimate claims? If the answer is yes, this gets to proceed. If there's a problem, though, with how it was pled or there's a jurisdiction issue, right, then, potentially we can get the entire lawsuit thrown out. So what MLC does is they go, well, what we think Spotify is arguing here is here's all the new stuff that they argued that's not even in the complaint. So here's a list. They go, Spotify asserts that it, quote, has invested heavily in creating and acquiring other non-music forms of content. Spotify asserts that such non-music content provides greater value to customers. Spotify asserts that such non-music content attacks and retains customers on the Spotify platform. So, like, they're trying to just argue, this is of a separate and distinguishable value. Spotify asserts that the MLC's position profoundly devalues the contributions of the tens of thousands of book authors whose works are available with a premium subscription, from literary luminaries to mainstays to bestseller lists to up-and-coming writers who are finding their audience. Well, I don't think it's so much that we're like devaluing authors. I think the mechanical licensing collective's concern is that right now there's already so much dilution that has happened on platforms, like Spotify, right? And you guys are not getting paid very much, right, for your mechanical royalties. And so that's the problem. And they go, well, if you're going to further dilute it, because now in the royalty pool calculation, we now have all these audiobooks. So what do you guys think? So like I said, this is pending now. The court will take a look at this and, make a determination. From what I can see and what I have read, I don't know that this is fairly and properly situated for dismissal, but we'll see what the court does with this one.